Good afternoon, ladies and gentlemen. My name is Alon. I'm part of the business development team here at Access Law. I'm going to start off by letting everyone know I appreciate the hour we're going to spend. It is jam-packed with all kinds of valuable information that I think everyone will find very interesting. First thing I'm going to start off is I'm going to introduce two other members of my team. So I'm going to have Brianna say hello to all her partners and friends who have joined today.
Hello, everyone. This is Brianna Frith. I just wanted to say thank you to all partners and all future partners of Access for joining. And I am a part of the amazing business development team at Access Law, and we're happy to have you here with us.
Thank you, Brianna. And our next member is Sam.
Good afternoon, everyone. I want to thank, along with Brianna, all our partners that have joined and future partners. I'm sure you'll find this very informative and educational. And we're looking forward to doing more business with you.
Excellent, Sam. Thank you. So we have handpicked and selected four very interesting individuals here at Access Law. I'm going to introduce all four members, and each one is just going to give a little bit of information about themselves, and then we're going to jump right to it. So first is going to be our CEO, Lena Koch.
Good afternoon, everyone. My name is Lena Koch. For those of you I don't know personally, and it looks like from the names I'm seeing here, I know probably most of you personally. Just wanted to welcome you today. Thank you very much again for taking your time this afternoon to sit with us for a little while. Hopefully this will be very helpful for you as well. As Alon mentioned, I'm the CEO of Access Law, and I have the privilege of working with this very talented and dedicated team of real estate professionals. So excited about the next 60 minutes, and we'll see what we can get out of it.
Thank you, Lena. Next up to bat is our head real estate lawyer, Shangs.
Hi, everyone. Most of you may know me as Shangs, but I also go by my legal name as Shangamir Rajaratnam, which is very cultural, very Sri Lankan. But so Shangs is definitely much easier to pronounce. So if ever you need to speak to me or reach out to me, please feel free. I've been with Access for 4 years. I've been in the real estate department from the beginning, and now I'm in this position as the head real estate lawyer. Again, if you ever need to ask me any questions or you need anything from me, please feel free to reach out.
Thank you, Shangs. Next up to bat is our real estate lawyer, Jasmeet.
Hello, everyone. So my name is Jasmeet, but I go by Jazz for short. Like Shanks, my name is very cultural. So it's easier to have a moniker that's easier to pronounce. I mainly specialize in the agreement reviews, preliminary agreement reviews for real estate. So the status certificates, new build agreements, and potentially also assignment agreement reviews. So if you have any questions regarding those would probably be best directed at me.
Excellent. Thank you, Jazz. And last but not least is our senior real estate clerk, Patricia.
Hi, everyone. My name is Patricia. As Alon has mentioned, I'm the senior real estate law clerk here at Access Law. I've been a law clerk since 2008, and I mostly specialize in our more complex transactions, such as private lending, commercial transactions, a lot of new builds, and anything that needs a special touch. It's nice of you to be here, and thank you for joining us.
Thank you, Patricia. Okay, I'm going to just go over two quick housekeeping, and then we're going to rock and roll. So although this is an interactive webinar, all correspondences are going to be done through our chat function, which is on the bottom center left of your screen. At any time during the webinar, you're more than welcome to ask and chat and post your questions, and we will try to get to as many as possible by the end of the webinar. And basically, at this time also, everyone's going to be muted. So once again, last thing you can do, anyone wants to do a chat, you're all set to go. And I think at this point in time, I'm going to pose our first question. So our first question is basically directed to Jazz and Patricia, which is a 4-part question. So it's what does a real estate closing transaction actually look like? And the first subheading we're going to discuss is signing documents with a lawyer. I'm going to pass that over to you, Jazz.
Thank you, Alon. So for signing documents electronically, it's very similar to this webinar where we have the client in front of us in a signing room, and then we attach an electronic signature to the document. So many of you are probably wondering, what is an electronic signature? An electronic signature is basically something that we can use to reliably connect the document to the signer, which means creating sort of like an audit trail that allows us to ensure that the signature is accurate. And the audit trail, we do that by recording certain details through our virtual platform, which include an IP address, a location of where the person is signing, and also their phone number and email address is recorded into that signature through the platform.
Thank you, Jazz. So I'll move to the next subheading, which is sending documents and registration to the land registry office. And I will give this question to Patricia.
So I'll tackle the easier aspect of this transaction first with respect to electronic registration. Electronic registration has not changed. It was already conducted electronically and the land registration office has not closed. So we have not experienced any changes or interruptions in terms of registering transfers or mortgages or any other instruments on title. With respect to sending documents, most firms are now allowing you to send documents via PDF. So we only have to send one electronic copy of the documents. For new builds, that's usually the exception. They do sometimes require originally signed documentation, in which case we arrange for it to be couriered to the builders. Sometimes we have had to have the documents be couriered from the client's home to one of our offices or homes so that we can commission the documents and then we forward it on to the builder. But we have been able to find workarounds in those situations and make sure that it gets done.
Perfect. Thank you, Patricia. I'm going to go right back to Jazz with regards to IDs and checking IDs and validity of them.
So we'll start with checking IDs. So the process with a virtual signing is a little different. What we require is normally we have the clients provide us a high resolution image of the IDs before the signing appointment. And then during the signing appointment, we also have them show us that same identification to ensure it's the same and the facial features, etc., match. In addition, with IDs through a virtual process, we always want to safeguard against fraud. And there are various ways we do that. For example, we use the MTO for driver's license. We use the MTO's free tool, which allows us to double check and ensure that the ID is valid. However, there are situations where people can also manipulate the ID. Even though that number is accurate, you don't know that the picture on the ID is the same as the ID being valid. And how we verify that is that there's usually a holographic image attached to the driver's license, which should match the actual image on the ID. And I'm going to show an example of that. So I'm just going to share my screen quickly here. So this is an example of an ID, and it's actually provided by the Alcohol Gaming Commission of Ontario, and it just outlines the key features of an ID. What I was talking about is see at the corner, right corner, there's a little holographic image, and then there's the actual image of the person. If someone has doctored the ID, normally those two images will not match. In addition, another way to check that the ID is valid is that this reference number, so here it's MZ9331796, this should match the back of the ID, and that is why we also require clients to provide the back of the ID. And here's an example of the back, which shows that it should match. In addition, the platform that we use is very encrypted, which means that it's unlikely that someone can manipulate the video because it isn't as common as Zoom or any other platform that someone might use. And yeah, that's about everything with regards to identification. Alon.
Thank you, Jazz. One of the very common questions that we've had over the last 90 to 120 days is the transfer of funds and money and how we are moving money around with the banks either closed, which there was a substantial amount of branches closed, and obviously at very limited hours. So I'm going to ask Patricia to talk about how Access Law is moving money around to our clients, partners, banks, and everyone else that is basically interested in those funds.
Thanks, Alon. So for fund transfers, for the most part, we have been able to transfer funds to other lawyers via wire transfer. In some circumstances, the builders' law firms do require certified checks. and we have been able to accommodate that. Our bookkeeper has been able to leave her home, go to the branch, certify the checks, courier them out as needed. But I would say 99% of our files have been via wire transfer. And for paying out mortgages or encumbrances, commission, broker fees, everything else, we've been doing a lot of variations. We do direct deposits to people's accounts. We've been sending out checks. We do wire transfers, anything that gets the money where it needs to go as fast as possible. In terms of receiving money, for example, the client's closing costs, the balance of their down payment, what we need to actually complete the transaction, clients have been able to go to the branch, and get a bank draft or a certified check. If not, we've been able to arrange for the clients to send us wire transfers. We try to limit the amount of wire transfers that we receive from clients because there is always the possibility that they do get held. So we've made arrangements with clients beforehand, at least 4 to 5 days before their closing date, for them to provide us the funds early, so that we can all rest assured that the money is in place. And on the closing date, we're able to disperse the funds accordingly.
Awesome. Thank you, Patricia. Okay, I will move on to our next question, which I will pose directly to Jazz, which is, a lot of our realtor partners have asked what they should be aware of on new build agreements. And since Jazz is an expert in this field, I will pose it to him.
Thank you, Alon. So me and Lena recently actually did a video on this where we explained the important clauses and information that you can find in a new build agreement, but I'll just quickly summarize again. What you should normally be looking for is, number one, the capping of costs. More specifically, the adjustment costs. So on closing, usually the builder will require certain costs to be added onto the purchase price, like development charges, meter installations, education levies, anything that they would be charged, they're going to try to pass on to the potential purchaser. So what you want to do is see if you can ensure those are capped ahead of time when you receive the contract from the builder's sales office. That way it limits any issues later on final closing, where the client is unaware of the requirement to bring in an additional 1 to 5% on top of their purchase price. Another few things to look for are assignment clauses, so ensuring that the client has the right to assign the unit, obviously in accordance with certain conditions, so that if they ever do go through any kind of financial difficulty, or if they ever have a change of mind, they can sell their interest in the agreement beforehand. And then also the right to lease if they are purchasing it for investment purposes. That ensures that they do not have to pay the monthly occupancy fee out of pocket, and that they can rent the unit during interim occupancy to a third-party tenant.
Perfect. Thank you very much, Jazz. I'm just going to repeat one more time. Anyone with any questions, I'd urge you to basically post it on the chat. And as we get to the end and we covered the 6 questions that we originally have called for this webinar, we will get to those questions. So thank you very much. And moving on, I'm going to pose this next question to Shangami, which is what is involved and how to close a real estate transaction with clients out of Ontario and Canada. We have a lot of partners who are dealing with investors, first-time home buyers that are either coming into the GTA or Ontario, and this seems to be a question that has come up substantially over the last few months, and this is why we've decided to add this question. So off to you, Shangs.
Awesome. So with the Law Society's new interpretation of presently in front of, we are able to conduct a lot of this through virtual means. So we meet with the clients by video. We send the clients the documents in advance just to review it to make sure everything's good. We try to mitigate as many, any errors in advance. We do that in general, but especially because it's not being handled face-to-face, we try to make sure that we allocate enough time to have the clients review the documents with us. We work together and ensure that everything is good to go. With the video aspect, as Jasmeet has mentioned, we get IDs in advance of the appointment to verify its validity. and to ensure as well that our documents are prepared correctly. Then when we meet with the clients by video chat, we ensure that the client holds up the ID alongside themselves. We use a secure platform for this, and we verify again. We have our own internal process of verifying ID. We have our own forms on top of the bank forms. Again, because the Law Society has interpreted, presently or in the presence of as virtual, banks are now on board with this as well. So we are able to get bank documents signed electronically, and we are able to facilitate a closing with the client not even being in Ontario. Now, when it comes to new build transactions or transactions where the documents, we require a hard copy or a physical copy, we again allocate enough time to ensure that the documents are prepared correctly. The client will send it to the client in advance. The client will then print out the documents. We will go through the documents again virtually, and then the client will courier the package to us in order for us to then facilitate whether we need to deliver it to the builder, or if the banks for some reason require a hard copy, which is not likely, but if that was the case, this would be more for builder transactions where our clients are living in BC or somewhere outside of Ontario, and they're purchasing property in Toronto. They would courier the documents to us, and then we would facilitate arranging the courier to the builder. So yeah, that's pretty much it.
Perfect. Thanks, James. I'm just going to take this opportunity, although we're speaking about virtual signings, which is a large, obviously part of the closing process today, I still want to mention that we are still offering in-person meetings in our office, and we are still offering a mobile service that allows our people to go in anywhere in Ontario and offer that service in-house or in the place to work. So we're offering all three services. Obviously now, the most popular one is where everyone sits, and we're doing it virtually. So I will move on to the next question to Jazz, which are, what are the common reasons for clients canceling new build agreements at the agreement stage?
So the most common reasons why clients cancel agreements at the preliminary stages is, again, closing costs. Usually when they come to us, they ask for a breakdown of the costs, and we can only provide the ones that are stipulated or where there's a limit. Any costs that aren't limited, clients usually don't like that because they do not know how much they'll be required to bring in on final closing. We do sometimes provide estimates based off other agreements we've seen in the area, but those are not 100% accurate. In addition, closing dates, sometimes clients are unfamiliar with the idea of a tentative closing date and an outside occupancy closing date. So once that is explained to them, they usually have some hesitation as to the potential for delays. And monthly occupancy, some clients are not aware that they have to pay a monthly occupancy fee during interim occupancy, and that can be a reason why they cancel the agreement.
Just to add on to Jasmeet's points, another thing that we've noticed is when a client is purchasing a new build property as an investment property, they sometimes are not aware that they have to account for that additional $24,000 HST rebate or the HST. Although they have to pay for it upfront on final closing, they are able to get that money back from the CRA, provided that certain conditions are met. So I think it's also important to, that the clients are aware that if this is an investment property, additional funds like that, additional HST is applicable, but you are able to receive a rebate, provided that those certain conditions, the certain CRA conditions are met, and then that's something that should be brought to their attention as well.
Amazing, thank you. We're living in a new world today with COVID-19, and we know that this affects basically not only the real estate, mortgage, but everything else in everyone's life. So one of the next questions that was posed to us are, why are clients' new build agreements being delayed due to COVID-19 with no compensation? This is a constant question that's being asked to our lawyers, our clerks, and we thought it would be an important question for us to get Jazz to answer.
Thanks, Alon. So the reason behind that is in the Tarion addendum that's attached to all new build agreements, there is a clause that allows the builders to delay the closing unilaterally without any compensation if there's an unavoidable delay. And in that definition, a pandemic is included, which means that because of COVID-19, construction workers, et cetera, are not able to work. The builder, this is considered out of the control of the builder, and they're allowed to extend the closing date until the pandemic has ended or until they're able to resume construction. And that is the reason why these agreements are being extended without any delayed warranty compensation being paid out.
Okay, perfect. Thanks. That's great. Our next question is going to have to do with assignment sales, which is how can agents help during an assignment sale, along with some typical clauses to include. So I'm going to pass this again on to Jazz and give us some insight into that.
Yeah, so for assignments, how agents can help is just to include the suggested clauses that are important. So that would include clauses ensuring that would protect the client, including a clause, for example, to allow for the HST. So there's basically, if someone is living in the property, the client will not qualify for the HST rebate. So normally you can include a clause in the agreement that states that the assigner has never lived in the property and neither has a builder ever lived in the property, which protects the assignee's right to claim the HST at a later date, the HST rebate. Another clause in indemnity. So it usually when the builder signs an agreement with the assigner and assignee, it states that the assigner will be liable if the assignee is unable to close. So what you can include in the agreement, assignment agreement of purchase and sale, the OREO form, is an indemnity that states that if the assignee is unable to close, they will indemnify the assigner for any costs that they may have to pay out of pocket as a result of them having to now close the transaction. In addition, you may want to include a force majeure clause. So that's for the situation if the builder is not able to complete the property, what happens to all the funds that the assignee has paid to the assigner? So the force majeure clause can state that, if there's a situation like an earthquake or something that results in the builder being unable to complete the unit or home, then the assignee will be given back the deposits, et cetera, that they have paid to the assignor, because that's not mentioned normally in the OREO agreement. Additional clause would be also making sure the agreement is in good standing. So if there's any upgrades that need to be paid out or anything of that form, you want to include a clause that the assigner is positively stating that those have all been completed and paid out before the closing. And in addition, we also want to clarify the payment structure. So a lot of times we have issues with the payment structure being unclear, which means there's usually like the deposit, it doesn't state when the deposit should be released. So we want to clarify when the deposit should be released, when the final payment to the assigner should be made, and if there's any interim payments in between, you want to clarify exact dates as to when they'll be paid and when they'll be released from the lawyer's trust account or from the brokerage's trust account. Also, an assignment closing date should be clear. So we normally recommend that the assignment closing date should happen within 5 days of receiving consent, so that every party has a set date as to when this agreement should be finalized, and that we can move to the next stage, which would be the occupancy or final closing. And those are the main important aspects of an assignment agreement that realtors can go through to ensure smooth closing.
Perfect. Thank you very much, Jazz.
Alon, can I jump in for a second there, if you don't mind?
Absolutely. I'll take
You off track a little bit. Jazz, those were actually some great clauses that you went through. I know we only have an hour here, and each of those clauses actually probably could have an entire webinar dedicated to them, but that's for another time. I'm just wondering, because I know, we have people reach out to us all the time asking for help with clauses. I just wanted to, I guess, mention to those of you who are listening and saying, well, that's all well and great. I understand what I have to include, but I don't know how to draft that. Please feel free to reach out to us. That is specifically what we're here for, is to help you with these kind of things. We don't expect that, you're going to be able to kind of like Google what's the right clause or know exactly how to do it. We can help you with these clauses. We do it all the time. We have templates available. And, if you are in a situation where you're drafting, an assignment agreement and you just don't know exactly how it should be worded or how it should be included or whether it should be included, do feel free to reach out. That's what we're here for. We can help you with that, and we can certainly give you guidance in that respect.
Perfect. Thanks, Lena. So I'll remind one last time, or once again, that any questions you have, we can take them on the chat. We're going to move to answer some of those questions now on the chat, and I'm going to ask Lena to take a look at them and decide who she best feels fit to answer those questions on the right-hand side of her screen.
All right. Now I'm going to get in trouble here. Okay. Before we jump right over to these questions, I wanted to quickly touch back on something that Jazz, you mentioned earlier in the webinar when you were talking about various ways that we authenticate identity and we look at ID documents. And you mentioned that one of the things that we do is we actually go to the MTO website a lot of times and we'll verify that an ID is in fact an ID, essentially that a name matches to the number that's on the ID and other relevant characteristics. I was wondering, does anyone have that URL on them? It might be nice if we could just post that to the chat, because I know obviously probably everybody who's on this call right now has to check IDs in various situations, and sometimes it's nice to just have that on hand. I don't have it on hand, but I know we use it all the time, so I'm sure someone can throw it up in the chat. I'm sure if you Google it, it'll come up too, but it's relatively new, so it's not usually the first search result. So if someone could maybe share that, that would be a great start. Okay, so let's take a look at some of the questions.
Yeah, so I'm just going to share it now.
Okay, thanks, Jazz. That's great. Okay, so first couple of questions are actually related to one another. Does it cost twice if I need to remove and add a name to the title? So I'm going to interpret that in a certain way, and I'm going to tell you how I'm going to interpret that. If it's different from the way, if your question is different than the way that I'm interpreting it, please just put it in the chat that it in fact is, you were asking a different question. But how I'm interpreting that question is, let's say I'm buying a property, or I have a property with a lawn, and I want to take a lawn off of the title, and I want to add Brianna to the title. And what it looks like you're asking is, do I actually have to pay double because I'm removing a lawn and adding Brianna all as part of the same transaction? Okay, so that's the assumption. And Trish, I know you probably can answer this in your sleep, so over to you.
Yes, absolutely, I can. We do a lot of title transfer transactions. That is exactly what we believe that you're asking here. And in a word, no, you do not have to pay twice. It is one transfer that's registered to remove the previous person that's coming off of title. And at the same time, we add in the new person. So you don't have to pay registration fees twice. You don't have to pay legal fees twice. Everything is all related to one transaction. And in terms of the second part of your question, how long does it take to do the title change? Just like everything else that you register on title to a property, it is immediate. It is electronically registered, and title is deemed to have been conveyed at the moment that you register that deed. Title changes can also be done at the time that you do a refinance, and that's frequently when we find people do. For mortgage approval reasons, they need somebody off, need somebody on, whatever the case may be. We typically register the transfer in conjunction with the mortgage. So they are subsequent registration numbers. We register the transfer, and then immediately after we register the new mortgage, and it can all be done as part of one transaction.
Perfect. Thank you, Trish. So let me ask you a question. If, just building on the second question that we have here, if for whatever reason I decide that I actually want to do the title transfer before we do the refinance as part of a separate transaction altogether, would that cost more? And would that be a more involved process?
Yes, it would. So if you wanted to do a title transfer and then in a couple weeks you plan to refinance, it would be more expensive to do it that way. You would be paying separate legal fees for both aspects of the transaction anyway, but we would need to wait for the transfer to be certified before we can proceed with the refinance. And for title insurance purposes, that would raise a red flag for title insurance. So if we acted in both transactions, that's not a problem. We can easily explain to title insurance what happened there and why the transfer was done previously. But if there's ever a transfer that's registered within 6 months of the date of a new mortgage going on, it does raise a red flag for title insurance purposes.
And just to add to that as well, if there's an existing mortgage on the property and there's the same people on title, whomever's on title must also be on the mortgage. So if there is a title transfer happening where one person's being removed, but the mortgage is still registered in two parties' names, in order for us to complete that title transfer aspect of it and remove the party, we actually need to get consent from the bank to do that. So we wouldn't be able to, we would definitely need consent from the bank to complete that aspect. So to remove an individual or even to add an individual without adding them to the mortgage. So that's definitely something to consider as well.
Okay, perfect. Let me ask you another question. I'm throwing my own questions in here, even though I know the answers to them. Would there ever be sort of a conceivable reason why you would want to do the title transfer before the refinance? I haven't come across that myself. And I think sometimes, people might be under a misapprehension. Oh, I need to change the ownership structure before I refinance, whereas really it should be done as part of one transaction. But have you ever come across any situation where there was a valid reason to actually do it separately as prior to refinancing?
The only circumstance that I can think of where that has happened is in the case where they were refinancing with a private lender. And the private lender's solicitors wanted the transfer to be completed beforehand, so that when they drafted their documents and everything was done for the mortgage that was going on, there would be no discrepancies between the names that were on title and the name that was going on the new mortgage. Usually they're done in conjunction, and we work with the lender's lawyers to have that done at the same time and provide an undertaking to register the discharge along with the mortgage. But in some cases, they could want the transfer registered beforehand.
Okay, perfect. That's great. And before we move on, it looks like the person who asked the question just had a little bit of follow-up on further details. So I'm just going to add a bit of color to the scenario. So it looks like this title transfer refinance scenario, just a minute, the lender in this case was going to pay for the refinance. And it looks like the mother was going to be removed and the son was then going to add his wife to title. The mother only owned 1%, so probably was initially put on title as a guarantor for the mortgage, I would imagine. So in this case, if you're worried about, hey, I want to do the title transfer before the refinance because the lender is paying for the legal fees, we would still do it all as part of one big transaction, and we can just split up those fees and have the lender pay for the refinance component and the client pay for the title transfer component. We do that all the time. It's still better to do it as part of one transaction because there are less overall fees. Clients are coming in to sign one. Trish, I feel like you want to add something here.
Oh, no, I was just going to say exactly what you said. And then the clients can only come in. They only have to do one appointment. It just makes it a lot easier for everybody involved. And we tend to give discounts on our legal fees when people are doing transactions in conjunction. So it's a cheaper rate to do a title transfer and a refi together versus doing a refinance and a title transfer separately.
Perfect. Okay, thank you. Okay, moving on to the next question. How do law firms protect themselves from money laundering? I know we've actually touched on this to a great extent already. I'm not sure, Jazz or Shangs, if this would be better directed to either of you.
So with money laundering, so that's what so if the client is, usually we get funds from the client who's completing the transaction. And we get, that's why we actually prefer certified checks and bank drafts that come from the bank directly, because it's essentially cash and it's coming from the bank and it's being deposited into our account. And it's coming out of the client's own bank account. So that's one aspect of, or that's the main part of why we require certified funds or a bank draft to avoid, any issues with that. Yeah, Lena, do you have?
No, that's perfect. I think, there are a lot of different elements to money laundering. one of the big ones, and one of, we have meetings that we go to all the time on these topics so that we're always staying on the cutting edge. Because let's face it, real estate is an area where fraud happens. It just does. It always has. It's always going to. What we want to make sure is it doesn't happen to us, and it doesn't happen to our clients, and it doesn't happen to our partners. So our job is to make sure that we are at the absolute cutting edge of knowing what are the new money laundering schemes, what are the new fraud schemes that are happening. So all of these little tricks that Jazz showed you earlier with the IDs, he's got a bunch more up his sleeve. We absolutely know every single trick out there that is sort of commonly known right now to people who are looking at these types of things, to be able to assess as well as possible, are you the person who you say you are? So one sort of common thing that happens in real estate fraud situations, fortunately, we have never had to deal with one, probably because we have a lot of systems in place. But let's say I will pretend that I'm Sam, for example, and I have a fake ID made. My name is now Sam Galanis. I go and I take out a mortgage on Sam Galanis's property. Thank you very much. I've got $1 million in my pocket. And sorry, Sam, you've got a big old mortgage on your house and I am off to Barbados. See you later. I'm retired. So these are the types of things that happen often. So what we do is we are very, very careful to make sure that we ID clients properly and thoroughly. We also make sure that we're constantly, we're very careful with the parties that we choose to work with, that we make sure that we know our clients well. And whenever we're doing virtual appointments, everything is recorded and stored. So if most people who are about to, commit fraud or money laundering are not going to want the entire thing recorded. So we're very careful about that. We have a number of other things that we employ. Not all of them we kind of talk about publicly because we like to sort of keep some of our secrets. But what I can say is that it is a real problem out there. It's always going to be. But what's important is that we stay ahead of that curve and make sure that we are at the absolute cutting edge of what's going on. And we have our sort of protections in place, which we do. So on to the next question. Do you work with brokers to register private mortgages? I'm going to switch things up a little bit and pass this question over to Alon. Even though you're not meant to ask these, I know you can answer this one easily.
I appreciate that. Thank you. So
no problem.
The answer is at Access, a large part of our business is private mortgages. We actually offer and have departments representing both sides. So we can, any transaction under $50,000, legally we are allowed to represent both the lender and the borrower. Once we break that threshold of $50,000, one law firm has to represent the borrower, one law firm has to represent the lender, and we can offer, we do offer both services. So we can do lender representation and borrower representation on private mortgages. So the nice and simple answer is yes, we can register private mortgages, and we're involved in all aspects of private mortgages right across the board. So that's pretty much the simple answer for that.
Nope, that's exactly how I would have answered it. We do a lot of private mortgages. We represent the lender, we represent the borrower, we represent both if it's a small amount. So absolutely, that's a big area right now, as I'm sure most of you know, and we're heavily involved in that. Okay, next question is, for first-time home buyers, do they get the rebate at the time of closing, or do they have to apply for this afterwards? So I'm going to pass that over to you if that's okay.
Yeah, and then Trish, if you want to add anything, you can as well. I saw you getting ready to unmute your mic.
Oh, sorry. Either of you can answer.
Fine.
I'll fight over it.
Yes, so first-time homebuyers do get their rebate at the time of registration. We account for it on, so the platform we use to register the transfer and the charge is TerraView. So we account for the first-time homebuyer rebate on the transfer, and then it's automatically calculated. And then, so the rebate will be automatically calculated in the land transfer tax section of TerraView. And then once we close the transaction, it is it's credited out of our account because we receive the funds from the client directly. So yes, it's applied at the time of closing.
Just to add to that, part of the documentation that the clients will sign is the land transfer tax and municipal land transfer tax if it's in Toronto, rebate affidavits. So we prepare all of that paperwork for them. We have them sign everything as part of their appointment. And then on the day of closing, before we register the deed, we fill in all of the details confirming if one or both or all of the parties are first-time homebuyers, and it's automatically credited. They pay the land transfer tax after the rebate is applied.
Yeah.
Okay, that's great, guys. And it looks like there was a follow-up question here. Is this true across? Is this true of all lawyers, or is it specific to the platform that we use?
So generally speaking, I can't speak to all lawyers, but most lawyers register through TerraView. That's how we are able to message each other the transfer. You know, the seller's lawyer will fill out the information. If we're representing the purchaser, we fill out the information, and then we collectively register the documents electronically. I've never encountered another lawyer that has not completed the transfer by electronic means. So we've always done this electronically. And then even when we're on the seller side of things, I do notice, or I've seen on most transactions, if the client is a first-time home buyer, it is accounted for on the transfer, and then it's credited on their account as well. So generally speaking, most lawyers should be doing this, but I cannot speak for all lawyers.
Yeah, that's right. So I've never, and Trish, you can probably speak to this as well. I've never seen a case where a first-time home buyer had to pay the full amount up front and then wait for the rebate. I've never seen this happen. If there's been a scenario that any of you know of where this did happen, I mean, off the record, my best guess would be what happened is the lawyer forgot to apply. I mean, and again, hypothetically speaking, the lawyer forgot to apply for the rebate and is probably applying on their behalf. Is that what you guys would say as well?
I actually have had a case where the purchasers themselves elected not to apply for the rebate on closing. And the only reason that they did that is because they weren't certain that they were first-time home buyers, because one person could have at some point in the past been put on title to their parents' home in a different country. And when the transfer was being registered, they still hadn't received confirmation that satisfied them that they were still first-time home buyers, because it's not just a land in Ontario. If you're on title to any property anywhere in the world at any time, you could be considered not a first-time home buyer. So in that case, we actually found out from those clients following closing that yes, they were first-time home buyers. I had held on to the first-time home buyer rebate documentation that they executed with our firm. So it was just as simple as me providing the documentation to them, and they applied to the ministry directly after the closing.
Yeah. And then sometimes they might not hit the qualifying markers. So if they're not like a PR or a Canadian, if they're not a permanent resident at the time of purchasing the property, then land transfer, even though they're a first-time home buyer, land transfer tax would be payable. And then if they get their PR status within, I believe it's 18 months, I will clarify with that, but off the top of my head, I believe it's 18 months. So within 18 months, if they receive that status of PR, then they can apply for the rebate after the fact. So if they don't hit all the qualifying markers to obtain that first-time homebuyer rebate on the day of closing, then yes, the lawyer would have to charge the full amount, and then the client would have to then go get the rebate themselves after the fact.
Okay, that's a great point. Maybe we can just speak for a second about what those qualifying factors are. I think most people know that, but they're not as straightforward as, you know, I'm a first-time home buyer, I get the rebate. The definition is a little bit more elusive than that. Do one of you mind kind of speaking to that, kind of breaking it down very concretely, what exactly, how you fit within that box?
Yeah, so you have to be 18 years of age. You have to reside in the property as your primary residence. So that's something that needs to be understood. A lot of people, sometimes it's not common, but sometimes it does happen that, your first purchase that you're making, you do it as an investment property and you're not living in that property. You must reside in the property within 9 months after closing. You must reside in the property as your primary residence. If you do not hit that qualifying mark, you do not qualify for a first-time homebuyer rebate. You must be a Canadian citizen or permanent resident. If you have a spouse, your spouse must have disposed, and if you have a spouse and your spouse has owned a property previously, they must have disposed of that property prior to your marriage. And I think that's it. Correct, Trish? Or am I missing one thing? No? Okay, yeah. So, yeah.
Okay, perfect. And I see there's a comment here saying, unless it's an assignment transaction in some cases, I guess that's referring to whether or not the rebate is given on closing.
I think that's more for new build transactions for the HST rebate.
That's what I was thinking too. Feel free to clarify in the chat if anyone wants sort of to further dig into that question. But yeah, I think you're right, Shangs. Yes. Okay, perfect. So, and how does that work then with the HST and the assignment? It's given later?
Yeah, so they would apply for it after the fact. They would apply to the CRA directly. Then there's two types of rebates, which is very important to note. There's the new housing rebate, and then there's the rental rebate. So if you're residing in the property as your primary residence, and for some reason, because it's an assignment sale, you don't get the builder doesn't award you the HST rebate, you have to make sure you're applying for the correct one. So even, and then same for the rental rebate. So if you are using the property as a rental property, you must apply for the rental rebate. You cannot apply for the new housing rebate. So it's very important. We had a client, we didn't handle the purchase of this, but we handled the refinance, and he basically applied for the wrong rebate. And then he used the property as his rental property. He applied for the new housing rebate. CRA gave it to him, but then after the fact, they actually charged him more money. He incurred penalties and different costs associated with the wrong rebate application. So it's very, very important that the clients are aware that they have to apply for the correct rebate.
That's great, James. And guys, feel free again to reach out to us on this. I know sometimes the difference is, you might be 99% sure, but that you have a little bit of doubt about something. If you have questions about this and you're discussing this with your client and you want a bit of clarity on this, or you just want to make sure that, what you want to tell them is accurate, feel free to reach out. Again, that's what we're here for. We're happy to be able to give you guidance in this respect. It's a lot of money. I mean, HST is a ton of money. These rebates add up and they really impact the affordability of properties for people as well. So do feel free to reach out to us on that one, on any of these actually. Okay, I think we've got most of the questions here. Let me check.
Lena, I have a partner or someone that had reached out to me on email. They were unable to make the webinar. But basically, I think the question probably would be interesting to everyone else here. And the question was basically, how fast of a turnaround time do we typically take to close a transaction? And I guess the caveat to that question as well is they're asking, what are normally the typical obstacles that as a law firm we face that are slowing down these transactions? So I thought I'd just kind of put it out there and maybe we can ask everyone, because I think that's a question that must be on everyone's mind here as well.
That's a great question, Alon. And I know Trish wants to answer this one because she's a super closer. She can close a deal in 6 hours. And now that I offered that, we're in big trouble.
Well, maybe not 6 hours, but pretty close. So I would say the issue that closes or slows down the closing is often for things that are out of our control. So items such as getting the insurance binder from your insurance broker. Because a lot of people are working from home, or they're at the cottage, or their office is actually closed down entirely, Getting documentation from third parties has been or can be difficult. At least it can take a little bit of additional time. Other things are property taxes. Sometimes the clients haven't been able to get property tax certificates or property tax statements from municipalities because the municipal services are closed. So generally it's all things that through our best efforts, the clients, the broker, we all work together to get these items, but it does take a little bit of extra time. Normally getting an insurance binder is as simple as a phone call before COVID, where now it can take several phone calls and some emails and getting in touch with alternative brokers at the same insurance company to try to get that done.
Okay, perfect. That's great. And how quickly can we close these deals?
Like you said, I've had deals where we received the mortgage instructions the day before and we've closed it the next day. So that's something where as long as the clients are available to come in and or do a virtual sign up with us very quickly, we can get it done. If they have everything ready, if their ducks are all in a row, if they're able to get the existing mortgage statements, debt statements, insurance binders, property tax information, and just meet any of the lender's conditions, then we can absolutely get it closed within 24 hours. Usually you would expect things to take at least 2 business days.
And again, it's never going to be us that's sort of holding up a transaction. If it can't close as quickly as we would like it to, it's usually because we're waiting on mortgage instructions or waiting for a client to be available to sign documents. We will work as fast as you need us to, for sure.
Absolutely.
I have one more question here that I actually think might be interesting if we have a minute left. And I think, let's see, the builder often has clauses that they keep the rebate and for the buyer to reside in the new build. Is there a way around this? Shangs, Jazz, either of you, neither of you? Does that question make sense, or do you want to ask that to be rephrased? I'm wondering if...
Yeah, is it?
I think I interpret it as he's discussing the assignment of the rebate, how often purchasers as part of the closing package assign the first-time home buyer rebate to the builder and the builder applies, but they do get credit for the amount of the rebate on closing.
Oh, the assignment rebate. Yeah.
Yeah, for the assignment rebate.
Okay.
Yeah, I think we're talking about the HST rebate, right? That the builder.
Rebate. Sorry, yeah, HST rebate.
Yeah, the HST rebate, that the builder keeps the HST rebate, but they give the rebate immediately to the buyer in the agreement price. So normally the agreement price is stipulated as including all HST net of the rebate. So if the buyer wants to apply for the rebate themselves later on, I wouldn't normally recommend that because it's a longer process and that the builder's saying that they're going to take care of it as long as it's your primary residence. There should not be any issues because you're receiving the entire rebate. However, if they want to keep it and they want to apply for it themselves, then they can claim the property as an investment property, right? And then they will add the rebate price to the purchase price and they can claim it themselves at a later date.
Okay, I think we're going to take this time. We only got about a minute or two left. Unless, Lena, you've got anything that you want to add or take, I'm going to wrap this up if that's okay.
No, over to you, Alon.
Excellent. Thank you very much. So I'm going to take this opportunity first and foremost to thank all our partners that we're currently doing business with and the partners that have joined to potentially check us out and see if they are interested to do business with us. So I will thank you for your hour worth of time today. I will also thank the business development team and all our lawyers, clerk, and our clerk, Patricia, for taking the time off a few days away from month end, which we know is the busiest time of the year, And if anyone has any questions further to this webinar, we are going to be circulating probably in the next day or two an electronic version and a video of this. And otherwise, anyone has any of our contacts as well, feel free to reach out to us and we will move forward from there. So I wish everyone a happy Wednesday and stay safe and talk soon. Take care. Bye-bye.